morning, my lords.
Yes.
I appear on behalf of the appellant entry clearance officer. My learned friend, Mr. Paul Richardson, appears on behalf of the respondent.
Yes.
My lords, this case raises a short point of principle
Yes.
as to the correct construction of paragraph Gen 3.1 of the immigration rules, which I'll come to fairly shortly. What I propose to do in developing our arguments in respect of that point of principle is to deal with the following matters. Firstly, the background to paragraph Gen 3.1, and in particular a case called Lebanon.
Yes.
Secondly, an analysis of the text of that paragraph, Gen 3.1. Thirdly, our submissions on interpretation. And then fourthly, I will briefly refer to the Upper Tribunal's decision that the entry clearance officer challenges by these proceedings. And then I'll deal with our two grounds of appeal and any concluding remarks.
Thank you.
So turning to the background to the relevant rule, the starting point in my submission is the decision of the Supreme Court in Lebanon. That is at tab 8 of your authority file, beginning at page 235.
Yes.
The key issue in Lebanon was whether the immigration rules combined with relevant policy in setting minimum income requirements, abbreviated in the judgments as MIR, were compatible with Article 8's family life aspect. The key passages for our purposes in my submission begin at paragraph 93 of the judgment on page 268 of the authorities. And my lords, I've line marked these passages. I won't take you through all of them in the interests of efficiency. But my lords, I would invite you in due course to read the entirety of paragraphs 93 to 101.
Yes.
For the purposes of my oral submissions, I'll zoom in, if you like, on paragraphs 98 to 100, which begin on page 270.
Those are the ones that are in your skeleton, aren't they?
They are, my lord, thank you. But maybe I can take them relatively briefly, but in due course, and very shortly, I will make the point that paragraph 100 is of central importance in the case. Paragraph 98 recognised that the Secretary of State is entitled, as a matter of domestic law, to impose limits on sources of income that can be taken into account in showing that the, if you like, substantive minimum income requirement rules are met. But at paragraph 99 and 100, the Supreme Court explained that the same restrictive approach may not always be compatible with Article 8. So at paragraph 99, the court pointed out that there was nothing in the policy guidance that required a rigid approach to alternative means of financial support being taken into account. And it was pointed out that having regard to those alternative means of financial support may be required in order to comply with Article 8's family life aspect. At paragraph 100, we see the conclusion of the court's analysis. The court explained that the requirements of Article 8, summarised at paragraph 99, do not necessarily mean that the immigration rules as such were unlawful. The court explained as follows. What is necessary is that the guidance to officers should make clear that where the circumstances give rise to a positive Article 8 duty in the sense explained in jeunesse, a broader approach may be required in drawing the fair balance required by the Strasbourg Court. It's then pointed out in the last sentence that it remains open to the Secretary of State to indicate criteria by which reliability of such sources may be judged, sources of alternative income, but not to exclude them altogether. And then at paragraph 101, the court made a suggestion. It suggested that the Secretary of State may wish to consider relocating the provisions that allowed for the required flexibility, if I can put it like that, from policy into the immigration rules.
So just going back, this was at a time, as you look at the beginning of '99,
Yes.
that when the application was being considered or outside the rules, and at that time outside the rules meant because the rules did not sufficiently or adequately address the overall Article 8 balance.
Yes.
And the rules were then subsequently changed to seek to incorporate the Article 8 balance within the rules.
That's right. And that is explained in the explanatory memorandum to the statement of changes that introduced those amendments to the rules.
Yes.
We have those at
To try and give greater clarity.
Yeah.
Can you also, when it says that give rise to a positive Article 8 duty in the sense explained in jeunesse, what were they there referring to?
Thank you, Lord. That is the point that I was about to deal with.
Oh, okay.
I'm very, very grateful. So,
because we don't have jeunesse in the
we
bundle,
don't,
do we?
and I anticipated the court may ask me about it. I've got copies of jeunesse if you want to look at it. As I'm about to explain.
Relevant paragraphs are cited in MM.
Exactly, and indeed in a case called
Paragraph 89 and 40.
Thank you, Lord. I'm very grateful. And indeed in a case called Agiaku, which I'm
Yes.
about to come to,
Okay.
that the nature of the positive obligation by reference to jeunesse is explained.
Anyway, what you were really drawing our attention to is that the suggestion that the Secretary of State might want to indicate the criteria by which reliability of such sources may be judged.
Yes.
Yeah.
So let me just deal with the observation about positive obligation in paragraph 100, because I do think that is important to have clear in the court's mind. The positive obligation is, in my submission, the obligation that arises in this context, in the context of migrants who don't meet the requirements of the rules, who aren't settled, after the analysis of Article 8.1 and Article 8.2 is completed. So, to use the terminology of the Strasbourg Court, once you get to the stage of assessing fair balance, what the domestic authorities would call proportionality, at the end of that process of assessing fair balance, if the fair balance falls in favour of granting immigration status, then the positive obligation arises under Article 8.2. And this was explained in the Agiaco case at paragraphs 40 to 41. Agiaco begins at page 207, it's behind tab 7. Paragraphs 40 to 41 are on page 224. We don't need to spend too much time on paragraph 40, but paragraph 40 refers to jeunesse and explains the approach that the Strasbourg Court has taken to non-settled migrants. And it acknowledges that the Strasbourg Court has used the concept of a positive obligation in that context. But at paragraph 41, referring to an earlier decision of the Supreme Court called Hashem Ali, which is cited at paragraph 41, the court explained that the analysis for the purposes of domestic law and Article 8.2 does not differ in cases where a positive obligation is said to arise and in cases where a merely negative obligation is said to arise. what matters is that you go through, if you like, the Rasgar stages, and you consider what the outcome of the fair balance proportionality analysis that I've just sought to summarise is. If the outcome is that you should grant status to a migrant, immigration status to a migrant, then you must do so, and that's the positive obligation. The positive obligation is to take positive steps to confer immigration status on a migrant in order to show respect for their Article 8 rights. So that's the positive obligation in my submission that the court in Lebanon, the Supreme Court in Lebanon, is referring to at paragraph 100.
Gen 3.1 and 3.2 are really about how you get to that
Yes.
result. You're not putting the cart before the horse and saying there is an Article 8, therefore I must go back and actually permit other evidence, because you don't know at that point.
Yes, that's right.
So as we understand it, the lower the could is because there's a risk that unless you take account of the procedural right, namely looking at alternative evidence, there might be a breach of Article 8.
Yeah.
So it's an intermediate procedural step. It isn't the ultimate decision. You take account of the alternative evidence. Doesn't necessarily mean to say you grant you grant someone any rights.
Yeah, exactly. That's right. That's right.
That's the difference. When you get to the next stage and you're waiving all the requirements, there's a would as opposed to a could.
Yes.
But at the intermediate stage, because you don't know for certain, it's a could.
That's right. That's what could is trying to get at,
Yeah.
if I understand, my lord. And I think the way my lord has put it to me is entirely consistent with our analysis in the written argument, which we maintain today. So the use of the word could in the relevant rule, as opposed to would in the subsequent rule, is designed to show that one is looking at that intermediate stage of the analysis.
You don't know at that point what the outcome is going to be, because you haven't yet looked at the financial data.
My lord, that's exactly right, with great respect.
And therefore couldn't be a would, because you don't know yet.
That's right. Now, you could the drafters of the rule could have used a hypothetical expression to capture that point.
Yeah.
It could have said assuming that it is accepted that the alternative sources of funding are reliable, applying the requirements in Appendix FMSC.
Yeah.
Would it then be disproportionate for the
Yes.
purposes of the positive obligation that I've
But then
summarised?
you've got to postulate a step forward, and you can never be certain about that.
Exactly. So instead, the draftsman or draft person has decided to adopt this intermediate formulation using the word could, and we say that's how to understand these provisions.
That's because we're dealing with a procedural stage, which is prior to the end decision.
Yes, and as my lord rightly points out to me with great respect, at that stage it's not known whether the alternative sources of funding are sufficiently reliable to meet the requirements of the rule. So you have to look at risk, we say.
Yeah.
And that's why we've used the formulation in the written argument to try to capture what could means that we have.
Well, isn't it the case that 3.1 is not really stemming from 100, it's stemming from 101? What 101 is saying is that there's a positive Article 8 duty, which means that it may be necessary to look at other reliable sources of earnings. And then 101 says that the Secretary may wish to consider whether it would be more efficient to revise the rules to indicate the circumstances in which alternative sources should or might be taken into account. And that's what 3.1 does.
With respect, I'm not sure that's right. I think it's important to look very closely at the text of paragraph 100, because I think actually there might be a slight error in the way that the text is expressed. If we look at the second sentence beginning, what is necessary, and then the second clause, where the circumstances give rise to a positive Article 8 duty. Now, as I've explained, if the circumstances give rise to a positive Article 8 duty, actually you don't need to look at alternative sources of support, because you know you have to grant. So I think possibly, and with great respect, the word could helpfully have been inserted before the word give and after the word circumstances.
Well, I don't know. I think 100 is looking at the concept that is in 3.2, isn't it? Because that's where in all the circumstances there would be a breach of Article 8.
I'm
It's
not sure.
the
I'm sorry.
Positive
sorry.
Article 8 duty in a broader approach.
I'm not sure it is, my lord, because it's paragraph 100 is clearly focused on the financial, the possibility of alternative sources of financial means. You can see that in the last sentence.
Jeunesse isn't concerned with.
No, it's not. But what Jeunesse makes clear is that a positive obligation can arise even if you don't meet the domestic law requirements for a grant of immigration status, having regard to a range of factors, going through the fair balance analysis. And as I read paragraph 100 in context, which of course, if we go I obviously went past these passages very quickly, but may have been a mistake. If we go back to paragraph 93, bottom of 268, and the heading immediately above that paragraph, it's quite clear that this section of the judgment is looking at how the rules deal with alternative sources of income. And what the court is explaining is you can't have a bright line or hard-edged exclusion of alternative sources of income in a way that's compatible with what Article 8 requires. So this part of the judgment is not looking at what I've called the all things considered Article 8.2 assessment, where you sweep in every relevant factor and conduct the fair balancing assessment. It's looking at the intermediate stage, where as to whether and in what circumstances it might be necessary to look at alternative sources of funding.
Well, because in 100, it says expressly they are entitled to take into account the Secretary of State's policy objectives, but in judging whether they are met, they are not precluded from taking into account other reliable sources of earnings or finance. So that's the general position, as then pertained, without there being any provision in the rules.
Yes.
And then what they say in 101 is, well, they can indicate, the Secretary of State could indicate the circumstances in which alternative sources should or might be taken into account.
Indeed, I've never, of course, that's what it says, and that.
All that 3.1 is doing, as I understand it, is looking at all this and saying the Secretary of State's concern here is the practicality of looking at alternative sources, reliability, etc., etc. And all that 3.1 is doing is setting out in the rules when the entry officer may look at alternative sources.
Yes, so but in the light of paragraph 100 in particular, and I think my lord, you're absolutely right to, if I understand my lord correctly, point out that what's being suggested at paragraph 100 is that you go through the Article 8 fair balance assessment. What Gen 3.1 is doing is saying to decision makers that in circumstances where there's a real risk that if you don't take into account possible evidence of possible reliable alternative sources of income, then there would be a breach of Article 8. That's what the rule is designed to do.
That's answering the question, isn't it, that's posed to us today?
Yes. Well, I respectfully submit that is the right answer, and that's what these passages are looking at. There are, as I've explained, this section of the judgment is not looking at what I call the all things considered Article 8.2 assessment. It's focused on the circumstances in which Article 8 may require or does require regard to be had to the possibility of alternative sources of funding.
Yes.
I'm very grateful. It's probably helpful to look at the text of Gen 3.1 now. It's behind tab 1.
So that's the background.
That's the background, and if you like, the purpose to Gen 3.1. The text of Gen 3.1 is on page 8, going over to 9 of the authorities. Unfortunately, the text is cut off across a page. We can provide a single-page document if that will help in due course, but I think we can work from this. I hope we can work from this.
Sorry, can you give me the page number again?
Page 8 and 9.
Thank you.
Behind tab.
Yep.
So it's Gen 3.1.1. I won't read it out, my lords, but I will invite you to remind yourself of the text of 3.1.1.
It's a bit easier to read than your skeleton, isn't it?
I think it probably is because of the way this is split across the page, so forgive us for that.
Or in the judgment.
and the judgment. Yeah, it's all there, and I'm sure my laws have spent some time looking at that.
Yes.
I would, though, emphasise or draw attention to sub 2 on page 9, because this paragraph tells decision makers what to do. If it's concluded that you go through
Yes.
1B
Yes.
and you're satisfied that the requirements in 21A2 of Appendix FMSE are met,
Yes.
2 explains that you then accept that the relevant financial requirements are met. Now, just to sort of flag the point, this is inconsistent with my learned friend's gateway analysis, where it suggested that if you go through Gen 3.1, you don't immediately obtain, if you like, a benefit. All you do is allow the decision maker then to have regard to alternative sources of funding when conducting the all things considered assessment at the stage of Gen 3.2. In my submission, that's not how this rule works, looking at its clear terms. What it does is allows alternative funding to be taken into account if the requirements in Appendix FMSE are met. And if those requirements are met, then the substantive MIR is then deemed to be satisfied. So you meet the financial requirements.
Yes.
And on the facts of this case, that would mean that irrespective of Article 8, the respondent was entitled to entry clearance under the rules.
Yes, it's an alternative means of satisfying the financial requirement.
Yes. And because in this case the only issue between the parties was whether the financial requirements were met, that meant that, leaving aside what Article 8 requires, if the respondent could get through Gen 3.1, she would be entitled to a grant of entry clearance. Forgive me. Forgive me.
Yes.
So those are the relevant provisions. I suppose I should just also highlight Gen 3.2.
Yes.
Which has been set out in the written submissions as well. Gen 3.2 and the subparagraphs set out what I've termed an all things considered assessment. It's designed to ensure that decision makers consider whether a decision is compatible with Article 8.
This is the general compliance with Article 8 provision.
Indeed.
Yeah.
I called it an escape valve or an all things considered assessment, but essentially what it's doing is sweeping into the rules or bringing into the rules the Article 8 proportionality assessment that would have to have been undertaken outside the rules if this provision was not included in the rules.
Yeah.
So turning then, unless there are any questions from the court, to our submissions on interpretation. The first point I just want to deal with is a quick reminder to the court as to the relevant principles. I don't need to spend very much time on these at all, I don't think. The relevant principles in respect of the interpretation of the immigration rules were recently reconfirmed in a case called Wang, a decision of the Supreme Court in a case called Wang. That's at tab 3, page 71 and following of the authorities. The relevant passages are paragraphs 29 to 31, and they begin on page 78. So the court will see on page 78, paragraph 29, that the Supreme Court reaffirmed and applied the test in Mahad at paragraph 10. We also have Mahad if you want to look at it. It's paragraph 10 is at page 280 of the bundle. At paragraph 31, on the following page, page 79, the Supreme Court noted that the approach to the interpretation of the immigration rules was no different than the approach that is followed when interpreting legislation, properly so called, save perhaps for some degree of relaxation of strictness. And so what that does is it brings in general principles of statutory interpretation the court to consider when interpreting the immigration rules. And on those
So in relation to 3.1, in a nutshell, what are the, if you like, interpretive policy considerations which apply?
I'm grateful.
Would one of them would be that the could relates to a procedural requirement. That would be, I mean, looking at any statute, you're asking yourself, is it substantive or procedural?
Yes.
This is procedural in the sense it is one step on the way to a substantive decision.
Yes, I would respectfully accept that. If that sheds light on the correct construction of the rule, then
But insofar as it helps one work out why could is different to would,
yes.
and why could necessarily has to be hypothetical because you don't know the result yet. So procedural context did seem to me to have at least some part to play.
I respectfully agree. I think the relevant drivers for interpretation or principles for interpretation are these: purpose, and I've tried to explain the purpose by reference to Lebanon, and I think it's entirely consistent with my law's point about procedure rather than overall substance. Context, the context being Lebanon, procedure, and the contradistinction between Gen 3.1 and Gen 3.2.
Would context also be that one's trying to get to a result which is consistent with Article 8 at the end of the day?
Yes, I mean, I don't want to split hairs. I've sort of pigeonholed that within purpose, but context is purpose and context in this case, I think, are very the significance of the overall scheme of the immigration rules, which is an aspect of context, and I'll just go to the PACCAR case in a moment for this. But the relevance of the overall scheme is explained in the written submissions for the entry clearance officer. The approach of the Upper Tribunal is so broad, we say, that it undermines the utility of having the normal requirements in terms of sources of income or financing in a way which would tend to undermine the overall scheme of the immigration rules. And fourthly, and finally, absurdity. We do respectfully suggest, with great respect to the Upper Tribunal, that the breadth of the Upper Tribunal's interpretation of the word could leads to absurd results. And I'll just remind the court of the correct principles in respect of absurdity now by reference to PA CCAR. So the PA CCAR case is behind tab 4.
This is the contingent funding in the Competition Appeals Tribunal.
I'm very grateful, my lord. That's the context. So it's a very different context, but it's set out generally applicable principles of statutory interpretation.
I have misfortune to have done 2 appeals about this judgment already.
My lord knows the case better than I do, then. At the bottom of page 99, the relevant principles of statutory interpretation are summarised by the Supreme Court, paragraphs 40 and following. They will be very familiar to this court. But I just highlight 2 aspects of the principles set out at paragraph 40 and following. The last sentence of paragraph 41 on page 100 states that the purpose and scheme of an act provide the basic frame of orientation for the use of language employed in it. So that supports my point about scheme and context. And of course, more broadly, context is always important when interpreting legislation. Paragraph 43, moving down page 100 and going over leaf, summarises the concept of absurdity as an aid to interpretation. And the headline in paragraph 43 is that although there are limits to the implications of the absurdity principle, it is a fairly broad principle.
You know, Parliament is intending to reverse the consequence of this judgment.
I'm sorry?
Parliament is intending to reverse this judgment through legislation.
Well,
I don't think it affects the analysis of what's meant by absurdity, which
No.
is really, does it make the measure impossible, unworkable, impracticable, inconvenient, anomalous, or illogical, futile, or pointless?
Yes.
Those are fairly broad there, and it may depend upon what end result you're desiring to come to. Your opponent might say that the result arrived at by the Upper Tribunal was precisely what the rules were intending to arrive at, and therefore they ain't any of those things. But
Well, I'll let my learned friend speak for himself.
Yeah.
He may be bold enough to make that submission. We say that would be wrong. I mean, the only reason I've emphasised para 43 and absurdity is just to point out that the principle is not a narrow principle. It's a fairly broad one. I think in the circumstances of this case, it's really the flip side, if I may put it like that, of purpose. So bearing in mind Lebanon at para 100 and the apparent purpose of the rule, is the Upper Tribunal's interpretation of the rule sustainable, bearing in mind the absurdity principle? That's how I would put
you
it.
could look at it another way. You could say that 3.1 being procedural and not being the ultimate decision would necessarily have a relatively low threshold, because the Secretary of State or the clearance officer can take into account alternative sources and then still refuse, because it would not give rise to an Article 8 breach, which is almost what the tribunal itself said in para 41.
Well, I'll come on to...
It came to 42.
Indeed. I'll come on to that, if I may, when I'm developing my substantive submissions, although I'll just flag the point now. We say that's not right, because, as I've explained, Gen 3.1 sub 2 requires the financial support to be taken to be treated as satisfying, the alternative
Yes.
funding to be treated as satisfying the requirements. And what that means is that on this analysis, on this sort of very broad approach taken by the Upper Tribunal, you have a mismatch between the requirements of Article 8 and and the observations in respect of Lebanon at paragraph 100 and how the rules operate. And that's very unlikely to have been intended.
So if it were very low and you took into account the data, the evidence, and then it meant you had to grant entry clearance, you might grant entry clearance even though there was no breach of Article 8.
Exactly, and we respectfully submit that is exactly this case because of the Upper Tribunal's finding at paragraph 41. The Upper Tribunal said in terms of paragraph 41 there is no breach of Article 8 in this case.
Yeah.
So you would say an inconsistent outcome.
Indeed, inconsistent with the context and purpose of the rules,
Which is to ensure Article 8 compliance.
in the context of looking at alternative sources
Yes.
of funding.
Yeah.
Indeed, my lord. That's a submission.
And the important point is that this intermediate stage should be part of an Article 8 assessment, not prejudged.
Yes, and it would be
It
anomalous.
could lead to a refusal, even if the evidence is taken into account.
Yes, and it would be anomalous. Yes, I mean if the other requirements in the rules were not met, but then that does throw up its own set of issues. But the point is, it would be anomalous if the way Gen 3.1 operates is more generous than what Article 8 requires.
Yes.
And that would be the position if the Upper Tribunal's interpretation of the rule is correct.
And that is because these rules are designed to achieve Article 8 compliance, not create something which is beyond Article 8.
Exactly, my lord. Thank you.
Isn't it inherent in, as soon as you have anything less than would, even if it's real risk, it's inherent in that you may end up granting entry clearance when there is in fact no breach of Article 8. It would be no breach of Article 8 to refuse. It must follow.
I suppose, yes, I mean, if you like, the difference of standard of proof means that there is that logical space for that outcome. I think I would have to accept that. But the approach of the Upper Tribunal goes so far beyond that logical necessity that in my submission it's impossible to justify. Because the Upper Tribunal, well, we'll look at the Upper Tribunal's judgment shortly, but the Upper Tribunal adopted such an expansive interpretation of Gen 3.1 that effectively it denuded the overall scheme of coherence and divorced the approach under Gen 3.1 from any sound correlation with the requirements of Article 8 having regard to Lebanon at paragraph 100. And that's my submission in response to those observations.
Can I just unpick that a little bit? What the tribunal did in paragraph 42 is somewhat different. Still trying to understand precisely the difference between could and would.
Yes.
My lord's point is that if it was would at this stage, then because wood is a higher standard, once you take that information into account, you will grant entry clearance. So it does predetermine the outcome. Whereas if it's could, you're only dealing with risk, and it leaves the entry clearance decision yet to be taken, and it could be a refusal. That could be,
Ultimately, yeah.
it could be, but isn't that a logical way of distinguishing between could and would?
Yes, which is why I've used the formulation of real risk.
Yes.
So essentially, because it's trying to get at
Critically, it doesn't prejudge the ultimate decision.
exactly, and that's right. So the formulation we've adopted it has been put forward because it tries to encapsulate the stage of analysis that
Yes.
Gen 3.1 is looking at, the procedural stage, if you
Yeah.
like, and the points that you and I discussed earlier, my lord, as to the, if you like, contingent situation that Gen 3.1 is looking at, because you don't know whether the alternative sources of funding are reliable at that stage. You're just looking at whether you should even look at whether they're reliable or not.
But that's the only basis on which you could refuse. Once you've opened this gateway, it's purely the financial requirement which is being analysed, not other elements.
Yes.
So the refusal would not be because of the application of Article 8 more generally, because that's 3.2. It's that you're considering the financial requirement, but it doesn't actually meet whatever the provisions are in
if you like, the substantive aspects of the financial requirement, because
Yes.
they vary from context to context.
Yes.
That's right, my lord, yes. So in a case where the only issue is whether you meet those substantive financial requirements, if you get through Gen 3.1, you get home, whether or not you would have got home, if you like, applying Gen 3.2 and the all
Yes.
things considered assessment.
yes.
And we say that's where the mismatch that this case throws
But
up.
it's my lord's point that there might be cases, because it's could rather than would, in which, by virtue of 3.1, you take into account financial resources, you do get entry clearance, even though you would not fall foul or satisfy, whichever way you look at it, 3.2.
Yes, I think I've accepted, as I think I must, that because of the formulation we've put forward, real risk as opposed to balance of probabilities, there is that logical space of, if you like, a mismatch.
Yes.
Um,
Because you're not making a finding that it would. You need to have exceptional circumstances which could render a refusal a breach of Article 8, because such refusal could result in unjustifiably harsh consequences. So you have to have, however you've placed it at real risk, real prospect, but you're setting it at quite a high level, because otherwise you say a lower level would completely undermine the intent purpose behind these.
so the way that the
These
rule,
this part of the rules.
yes, indeed, my lord, that's the submission. So the way these rules are drafted may, as I've accepted in answer to my lord's question, lead to that potential mismatch to some degree. But my submission is the court should prefer the interpretation that minimises the mismatch as far as is possible. I hope that's clear enough.
The thing is that all we're looking at here is a new provision by the Secretary of State as to in what circumstances you can look at alternative sources, and she can set that at whatever level she likes.
She certainly can. But the submission I've been making or developing is that the purpose and context of this rule is apparent from Lebanon. The Secretary of State is seeking to, if you like, follow the suggestion at paragraph 101 that the Supreme Court made in Lebanon. And so the Secretary of State is not adopting an approach that is more generous than what Article 8 requires. She's seeking to set out an approach within the rules that ensures compliance with Article 8,
Yes.
no more but no less.
Yes.
And there may be a degree of mismatch between compliance with Article 8 and a particular case given the way the rule is expressed, but that mismatch should be minimised as far as possible, because that's the best way to give effect to the intention behind this aspect of the rules in the way that I've explained by reference to purpose, context, overall scheme, etc. Moving on then, and I think I've probably covered a lot of the ground already, to our submissions on interpretation. We set out the correct approach to Gen 3.1, paragraph 38, 41 and 42 of my skeleton argument in particular. And I think the court has it. We've used the expression real risk to try to encapsulate the difference between could and would, as between Gen 3.1 and Gen 3.2. I've made the point that the rule could have been framed using a hypothetical test, but it hasn't been.
If I remember correctly, real risk is used in other fields in immigration, and you're not intending to use it in that context?
No, I'm simply trying to provide a helpful explanation for the use of the word could in context.
Let me just try and get a handle on this word could. I'm looking very strictly at the language in 311 little b.
Yes.
It is evident from the information provided by the applicant. Okay, so we know where we're looking.
Thank you.
Then that there are, now the word are assumes a present state of affairs.
Indeed.
And then there must be exceptional circumstances. So you've got to identify exceptional circumstances which exist because of the are, and then those exceptional circumstances could, but the could has to be read in the context of evidence which exists at the time of the exceptional circumstances, give rise loosely a breach of Article 8, if we don't take account of the information.
Yes, my lord.
In this context, does the word exceptional add anything at all? Because if you just had 6 circumstances which could, if the information's not taken into account, breach Article 8, you get to more or less the same end result as exceptional circumstances, don't you?
I think if the words would lead to a breach of Article 8 were there, I'm not sure, I don't think they are, then I think that's right. What exceptional circumstances is, they are, yeah, of course they are there. But what exceptional circumstances is doing is trying to remind decision makers of the relatively high threshold that applies in this context. Exceptional.
I see that. That may be why they're there, but you may get to exactly the same result even if the words weren't there.
Exactly. It might be more difficult though for decision makers because they might be sort of flailing around in the dark about threshold to some degree. We know that the threshold is relatively high in this context. See Agiaka paragraph 48, where exceptional circumstances is explained.
So I'm not either agreeing or disagreeing, I'm thinking it through. The word exceptional is really, it doesn't really qualify circumstances, it qualifies the test as a whole, that Article 8 isn't intended to be an easy route.
I agree.
I put it clumsily, but is that really what it's there for?
That's right. So exceptional circumstances and the reference to Article 8 is all ultimately a reference to the fair balance or Article 8.2 proportionality assessment that has to be gone through. And my lord is quite right to point out that assessment is undertaken by reference to what is evident from the information provided.
And that at the time the decision is taken, there are circumstances.
So it's exactly.
Which, and then could is because we don't know what the end result of that analysis will be when we open the door to the new information.
Yes, in the way that I've tried to explain.
So it could be a breach, and then that brings us back to what is that threshold, which you say it's really akin to real risk, something which is really material, as opposed to the language in paragraph 42, which is, if you like, it's the way it's described is less than de minimis. It's a possibility or a mere possibility.
Yes.
So a hypothetical possibility would suffice.
And not just that, as if I may interject, my lord, at any point in the future. That's another problem with the Upper Tribunal's approach.
It's hypothetical in the sense that it's in futuro, whereas 3.11b is you have to identify present facts or present circumstances. That's the important thing to me of the word are.
Yes, and that is an important aspect of this rule, which I respectfully emphasise. So you're looking at whether there's if you like, a sufficient threshold of a risk of a current breach. You're not looking at whether in the future there might be a breach because of possibilities that are effectively speculative at the time of your assessment.
Can you give us some examples? I mean, I think we might be chary of getting too much into speculative facts, but
yes.
What sort of factual scenario would constitute exceptional circumstances? Could it be, for example, that one of the persons who has, say Mrs. Khera, has a serious existing debilitating illness, which means that she couldn't travel? Would that be an example?
Everything will inevitably be fact sensitive, but yes, that is an example that comes to mind. And that seems to have been how the case was run below, at least in the first tier
But
tribunal.
that was rejected in paragraph 41.
Exactly. So in the first tier tribunal, the argument was effectively, well, I can't travel because of a hernia. That argument was, and that allowed me to rely on the threshold, that got me past the threshold required by Gen 3.1. That argument was rejected by the first tier tribunal, and in the upper tribunal, effectively, the court accepted that not only was the respondent able to travel in the light of her medical circumstances, but also, this is paragraph 41, there would not be a breach of Article 8 if her application was refused.
Right, it's only if you actually identify something which is below the level of, I think you would put it, likelihood.
It was not even that, my lord. The upper tribunal effectively said there will not be, well, did say there will not be a breach of Article 8 if the
I
application-
agree. So whatever the standard of proof you would say applies, the words which seem to me relevant in 42 are a possibility
Yes,
and mere possibility in the last but one line.
yes. We've identified the test the upper tribunal used as mere possibility. There's a degree of rhetorical value in putting it that way, I acknowledge, but effectively the upper tribunal put the test far too low. If that makes sense.
On one view, both of those tests, your view and the respondent's test, could work if since it's merely opening the door to permitting information to be evaluated. Because even applying this test, I mean, it's one of the surprising things about the judgment. On this test, it led to an outcome, whereas if it's procedural, it merely permits the information to be considered, which then leads to an outcome.
Yes. Yes.
The point, as I said, in 3.1, you are not actually conducting an Article 8 analysis.
No. Well, I'm sorry, my lord. I think you must be. You're looking at whether there's a real risk that if you don't at least look at the alternative sources of funding, there will be a breach of Article 8.
Well,
that must be the
alternative sources of funding can't have anything to do with whether there's a breach of Article, whether there would be a breach of Article 8 if you refuse entry clearance.
Well, I mean, if that was right, well, I don't think that can be right with great respect. I mean, going back to Lebanon, what the Supreme Court was explaining there is that there will be cases where if you don't take into account reliable sources of alternative funding, Article 8 will be breached.
Yes.
And there must be sufficient flexibility baked into the system, if I can put it like that, to accommodate that possibility. Otherwise, Article 8 won't be.
At this stage of the process, this is still when you're in the stage of assessing whether somebody should be permitted to enter as a right under the rules.
Yes, but the context, well, the language of Gen 3.1 is clearly looking at what Article 8 would require, or might require, could require, because it brings in real risk.
You do the whole exercise to determine, in a sense, whether or not you will look at the further information, the further sources, alternative sources.
I think that's right. Yes.
But you're not engaged. But you haven't here got to the stage of an Article 8 consideration because you don't know yet that they aren't going to meet the requirements. And it may be that at this stage you may not have even have been provided with the information by the applicant because they are at this stage they are trying to get through as a matter of right.
Well, that would not be right with respect, my lord, for two reasons. One, under the sort of scheme of applications, the applicant is obliged to put forward everything they want to say, and what they will normally do is to say, look, I meet the rules, but anyway, if you don't grant me what I want, breach of Article 8. Yeah. And Gen 3.1, this is the second point, as my lord has pointed out, refers to effectively information in the light of the evidence available at the time, indicating that Article 8 could be breached.
So it's the difference simply this, the 3.1 is, if I can use very loosely, it's almost a shadow Article 8 analysis, which that's why it's could, which then triggers the opening of the door to new evidence. Once you've got it, you're in the final stage, which is not the shadow, it's the substantive Article 8 analysis, which is why it's would. It's a tighter standard.
If you still don't get home, even though you've gone through Gen 3.1, if I can put it like that, then 3.2 comes in. In this case, 3.2 wouldn't have helped in light of the Upper Tribunal's findings, but because the judge held that 3.1 had been gone through, then the applicant succeeded anyway. But that's a strange outcome.
Yes, thank you.
That's our case on construction. I've drawn attention to the key interpretive drivers, and I think our position is tolerably clear. You have our position in writing if there's some error in the way I've expressed myself. Let me deal now with the alternative interpretations put forward by the Upper Tribunal and my learned friend. The mere possibility approach, as I've already indicated, we submit is far too generous or broad. It imposes a threshold that is too low, bearing in mind that the purpose and context of the rule, and indeed the language of the rule, which clearly requires exceptional circumstances looking at an Article 8 proportionality assessment of some form. We do respectfully submit, as I indicated earlier, that the Upper Tribunal's approach leads to absurdity. We also submit that the Upper Tribunal's approach is inconsistent with the overall scheme of the rules for the reasons I mentioned, namely it effectively denudes the usual income requirements, minimum income requirements and sources of income that can be relied upon of much, if not all, of their force or value. And ultimately, the Upper Tribunal's interpretation rests on an unduly literal and acontextual meaning of the word could. Unless there are any questions about those points, can I deal with my learned friend's interesting gateway analysis? We have 4 reasons why that analysis is wrong. Firstly, it is, with respect to my learned friend, inconsistent with the terms and structure of paragraph Gen 3.1. In particular, it's inconsistent with Gen 3.1 sub 2. Because as I understand my learned friend's argument in writing, he says that if you get through what he calls the gateway in Gen 3.1, all that does is allow a decision maker or tribunal to have regard to third-party funding, alternative sources of funding, at the stage of the Gen 3.2 assessment. That's not how Gen 3.1 operates because of Gen 3.12.
Yes.
Secondly, my learned friend's gateway approach effectively builds in the mere possibility threshold that the Upper Tribunal endorsed. And so it is flawed for the reasons I've given in respect of why the mere possibility interpretation is flawed. Thirdly, my learned friend's approach would be over-inclusive in practice.
I'm so sorry, could you just summarise 2? I was looking back to...
I'm so sorry. So 2 is that my learned friend's gateway analysis effectively builds in the mere possibility approach.
Yeah.
So for all the reasons I've given as to why that approach is wrong, my learned friend's approach does not work. The third point is that my learned friend's approach, as I understand it, would be over-inclusive, so as not to properly align with Article 8 and the requirements of Article 8 and MM Lebanon at paragraph 100, and I've covered all of that, I hope. And fourthly, and perhaps from a sort of prosaic point of view, most importantly, the outcome in this case, the Upper Tribunal in this case did not adopt the gateway approach. The Upper Tribunal expressly held that there was no breach of Article 8, all things considered, paragraph 41, and yet allowed the appeal on the basis of its broad interpretation of Gen 3.1. And I know that my learned friend, unless I've missed something, has not filed a respondent's notice to somehow seek to justify the upper tribunal's reasoning on other, for reasons other than those that it gave. And so we say, even if my learned
I'm just
friend-
wondering if that's quite the way the tribunal saw it. I understand what you say about 42, but in 43 they seem to say this is all about ensuring compliance with Article 8. They may have got that wrong,
Yes.
but what they thought they were doing was creating a very low threshold to ensure compliance with Article 8.
Well, I think it would ensure compliance with Article 8, but it would also go way beyond what Article 8 requires, which is the flaw there. But for the purposes of this point, my point is that in the light of the finding or conclusion of paragraph 41, that there was in fact no breach of Article 8 in this case.
Oh, I understand that.
My learned friend's analysis can't help him because he
But
says...
let's just come back to the point. In 41 he says no breach, but then maybe 43 is saying there is breach because there's a mere hypothetical possibility. Now you would take issue with that. That isn't a breach of Article 8.
Absolutely,
But
and it's inconsistent with paragraph 41. Paragraph 41 is seeking to encapsulate the test for proportionality by reference to Agiarco, paragraph 48 of Agiarco, the unjustifiably harsh consequences encapsulation of the fair balance / proportionality test. And what the Upper Tribunal is saying at 41 is there's no breach of Article 8 here.
I'm not certain. I mean, it may be a matter of semantics. The first sentence of 42 says it may not be on a likelihood test, but actually on a mere possibility test. It could do so, i.e. breach Article 8. But it may be a matter of semantics rather than substance.
Yes.
May not be.
I mean, my submission is the Upper Tribunal has not found that there would be a breach of Article 8 in the circumstances of this case. In fact, it's found the contrary, paragraph 41. And so I'm dealing now just with my own friend's gateway analysis, and I'm making the point that it doesn't seem to square with what the Upper Tribunal actually did in this case. Because my learned friend says that you go through the gateway in Gen 3.1, as he puts it, and that allows you to take into account alternative sources of funding for the purposes of the All Things Considered Gen 3.2 proportionality assessment. But on the All Things Considered Gen 3.2 proportionality assessment, my learned friend's client lost below, paragraph 41.
And interesting, 41 is drafted as a finding of fact. There are not any significant obstacles. It's not likelihood or anything like that. It seems to be a dispositive finding of fact. There are not. The only way around that in 42 is to say there's a hypothetical possibility.
Yes. But hypothetical possibility is never sufficient for the purposes of an Article 8 analysis. So to put it another way, a hypothetical possibility would not, even on the Upper Tribunal's analysis, be sufficient for the purposes of Gen 3.2. And so my learned friend ultimately has to rely on Gen 3.2 at the second stage of the analysis, and he can't in the light of the findings made by the Upper Tribunal. I hope that's clear enough. Those are the 4 points we say as to why my learned friend's analysis, as interesting as it is, just does not work.
If the Upper Tribunal was right, and that take paragraph 42 out of the context of Gen 3.1 and 3.2, it's almost a general principle that a breach of Article 8 can arise if you can identify a mere possibility that there would be circumstances giving rise to a breach of Article 8.
At any point in the future, I would respect.
At any point in the future, yes. But that's one hypothetical possibility. But that would apply outside the context of Gen 3.1 and 3.2. And
it would be wholly inconsistent with all of the learning in respect of Article 8. Article 8 requires the conventional fact-finding assessment at the date of the decision by the decision maker or tribunal. Looking at whether, in the immigration context, the decision to remove or the decision not to grant entry is compatible with Article 8. It doesn't allow for this broad hypothetical, we respectfully suggest, speculative assessment as to what could happen in the future. Those are our submissions on the point of interpretation. I'll deal now quite briefly with the Upper Tribunal's decision. I'm not sure I need to say very much about it because it's brief and I'm sure the court has gone through it. I'll just perhaps give some of the key references. So the decision begins at page 70 of the hearing bundle. The Upper Tribunal's legal analysis of Gen 3.1 is set out at paragraphs 20 to 27 And the Upper Tribunal adopted, as I've already submitted, a contextual, literal approach to interpretation, focusing on the word could. And we submit that that's where the Upper Tribunal went wrong. You have the findings set out at paragraph 31 to 33. I won't go through those, they're there for the court to see. Paragraph 31 to 33. And then the Upper Tribunal set out its analysis, in particular at paragraph 37 to 43. The key passages are paragraphs 41 and 42, which I've addressed already on a number of occasions, so I won't repeat myself.
Just coming back to paragraphs 22 and 23
Yes.
of the ruling, the tribunal concludes it doesn't address the point we've been discussing about the different roles that could and would play, one as procedural, the other as substantive.
Yes.
That may be said to be an omission from its analysis.
I would respectfully agree. It's a consequence of the Upper Tribunal's laser focus on the word could and its literalist approach to interpretation. Because that approach meant that it ignored or overlooked or didn't pay sufficient attention to purpose and context. I mean, it's right and fair to note that the Upper Tribunal did acknowledge Lebanon and the background to the rule, but it didn't properly factor that background in when interpreting the word could and the word more broadly. So, unless there are any further questions in respect to the judgment, I propose to leave that section of my submissions there. That brings me to the concluding section of my submissions. There are two grounds of appeal in this case, set out on page 63 of the hearing bundle. The first raises the point of interpretation under Gen 3.1. We put the ground deliberately broadly. And the second makes the point that in the light of the Upper Tribunal's finding at paragraph 41, on any correct view of Gen 3.1, the Upper Tribunal's decision is unsustainable. We say, for the reasons that I've sought to develop orally and in writing, those two grounds of appeal are plainly well-founded. What they mean is, we submit, that the Upper Tribunal's remaking decision of the 7th of July 2024 should be set aside and substituted with a decision dismissing the respondent's appeal, because there's no basis to go behind paragraph 41, which found that there was no breach of Article 8. If you're not with me on that,
well, putting it another way, your submission wouldn't it have to be that there are no, I don't know how it's phrased usually, but there are no, or a tribunal properly applying the law, there are no circumstances in which 3.1 applies in the circumstances of this case. So that it needn't be remitted for a hearing.
yes,
Because the Upper Tribunal could not reach any other decision
yes, my lord.
other than that 3.1.1 didn't apply in the circumstances of this case.
Yes, my lord. And the basis.
And there was no other basis on which the application might have been, or entry might have been granted.
Yes, my lord. And the basis for that submission is the finding at paragraph 41 that Article 8 was not breached.
So that if 3.1.1 didn't apply, and reliance was sought, I can't remember it was originally on 3.2, in other words, General Article 8, then the tribunal's finding means that 3.2 could not apply.
Yes. And we also say that in the light of the correct construction of Gen 3.1, whatever ultimately the court says that is, in the light of the finding at paragraph 41, actually Gen 3.1 could not avail this respondent. But if you're against me on that, then the Upper Tribunal's decision should be set aside and remitted for a fresh hearing, so that the Upper Tribunal can apply the correct, apply Gen 3.1 in the light of this court's construction of that rule. But our primary submission is that in light of paragraph 41, the Upper Tribunal had to dismiss the appeal in the light of whatever interpretation of Gen 3.1 the court ultimately settles upon.
Thank you. No, speak. Thank you very much. Yes, Mr. Richardson.
May it please your lordships, I'll begin by setting out our position and I hope helpfully drawing the battle lines, because it's our submission to your lordships that there are no circumstances in which applying the law as we say it should be, in which a tribunal armed with the findings of fact that were made by the Upper Tribunal could have concluded that 3.1 didn't apply. We would submit that the findings of fact that were made only permit one outcome, which is the application of Gen 3.1 and the appeal being allowed on the basis of the presence of alternative sources of funding. We accept that paragraph 42 of the Upper Tribunal's decision may be problematic because the hypothetical situations that are envisaged are situations that might occur in the future, but we would still respectfully submit there's enough in the Upper Tribunal's decision in terms of factual findings to inform a decision where 3.1 must apply. And perhaps the most useful place to start is where my learned friend ended up, which is with the findings that were made in the Upper Tribunal's decision, which we would emphasise include extremely robust findings on the ability of the family to meet the minimum income requirement through these alternate sources of income and savings as well. And
Well, you're entitled to say there is a finding that the minimum income requirements were met by the son. He's going to earn £35,000 a year, and they concluded that they were sufficient. That's
part of the finding, my lord, yes. So paragraph 32, that for several years he's had a gross income between 35,000 and 45,000, and it's worth pointing out at this stage that at the time we're looking at, the minimum income requirement was an income of 18,600 rather than the 29,000 that it currently is. In paragraph 33, 3 lines up from the end, the evidence submitted by the appellant, now the respondent, which we accept, is that he has savings of over £35,000. And then paragraph 34, Mr. Khera, that's the son, gave oral evidence. We formed the view that he is genuinely committed to financially supporting his parents in the United Kingdom. And those findings of fact informed the findings that are then made at 38 and 39 of the Upper Tribunal decision, which are on the reliability, the genuineness, the credibility of the alternate sources of funding. And of course, they're all findings which favour the appellant or today's respondent. So we would submit that the findings that there is an alternate source of income and savings that's capable of satisfying the financial requirements are strong indeed. And we would submit it would be an affront to common sense for them to be disregarded in any assessment of Article 8. And the approach that is being commended to you by my learned friend is one that would cause them to be disregarded.
Why are they I'm struggling a bit. Why is it relevant to an assessment of Article 8? Because Article 8 isn't concerned with assessing financial resources here. It's concerned with what would it be unduly harsh to refuse entries? It's concerned,
Lord, yes.
It's concerned with other matters, not.
My lord, we would say that's because if Article 8's engaged, and the tribunal found that it was engaged in paragraph 44 of the determination, then the Secretary of State is justifying the interference with the right to family life by reference to the need to protect the economic interests of the United Kingdom. And the ability of the family through alternate means of support to meet the minimum income threshold weakens the Secretary of State's justification for the interference with the Article 8 rights of the affected family. And so we would submit any assessment of Article 8 as one that has to involve an assessment of both sides of the proportionality balance.
That simply isn't the exercise which is engaged in Gen 3.1, is it? Which is
Can
what
I come to why I say it's relevant to it in a moment? But we would submit that if you're looking to see whether there are unjustifiably harsh consequences such that Article 8 is breached, it's necessary not just to consider the consequences, which may be a range of consequences from very severe and grave to less so, but also to look at whether those consequences are unjustifiably harsh. And the word unjustifiably, we would submit, imports consideration of the justification for the harshness.
But that all comes into 3.2, doesn't it? Because you do have to do a full Article 8 consideration under 3.2. Here, all we're considering at the moment is whether you can even look at the alternative sources under 3.1. And your argument is bootstraps, because you're saying in considering whether 3.1 applies, whether you can look at the alternative sources, you have to look at the alternative sources.
No, what I'm respectfully, sorry to interrupt, what I'm respectfully submitting is you don't have to look at the alternative sources to decide whether you can look at the alternative sources, but you have to acknowledge the claim that there are alternative sources when assessing whether the interference with family life is justifiable. What wouldn't ordinarily be a justifiable interference if the financial requirement was simply not met at all.
If the financial requirement isn't met at all, you don't need to worry about 3.1.
Exactly, and you'd go to 3.2 and there'd be an all-encompassing Article 8 assessment that would look at the strength of the public interest, balance that against the rights of the individuals concerned. What I'm respectively submitting is that for purposes of Gen 3.1, you have to acknowledge the fact that someone is claiming to have alternate support when making a decision, and look at whether, having regard to the claim that there is an alternative source of support, there's a risk that Article 8 would be breached. Article 8, we would submit, is more likely to be breached in circumstances where the strong public interest in protecting the economic interests of the United Kingdom is not served by permitting entry. In a case where that strong public interest isn't harmed by permitting entry, then it's far more likely, we would submit, that there are unjustifiably harsh consequences to the extent that Article 8 would be breached. And so we say that the question that should be asked by Gen 3.1 is a question, as identified by the learned remedy, whether or not there's a risk of a breach of Article 8. And if there is a risk of a breach of Article 8 or a possibility of a breach of Article 8, looking at the information that's currently before the decision maker and the circumstances at the time of the decision, then we would submit Article Gen 3.1 applies, but it's our submission that in assessing whether there is that risk, it's important to have regard to the fact that the public interest might be weakened by the presence of alternate funding, such that there's more chance to succeed under 3.1 than there would be under 3.2.
The thing is, we're being almost driven to look at the wording of the provision in response to this submission, and no doubt you're coming to that in a moment. Because 3.11 subparagraph B is not confined to obviously financial resources, as was pointed out earlier on, that there are exceptional circumstances which could render refusal causing a breach of Article 8 because it could result in unjustifiably harsh consequences. So that's a general, that's general wording, not that ignoring the potentially available other financial resources would result in unjustifiably harsh consequences.
No, but we respectfully submit, my lord, that you can't ignore what ultimately is an important part of the balancing exercise when deciding whether there's a possibility or a risk of there being such consequences. What might be proportionate in a case where someone's presence in the UK is a direct threat to the economic well-being of the country is less likely to be proportionate if they're not. And so we would submit that the proper approach is for a decision maker, having regard to the claimed presence of alternative funding, to determine whether there's a realistic possibility of there being unjustifiably harsh consequences such that Article 8 is breached. And we say, based on the findings of the Upper Tribunal in this case, the only answer to that question could be in the affirmative.
So you say the
respect of
money must
3.1.
be taken into account under B.
Yes.
Let me just look at the structure of this. So 3.111B, the B doesn't refer to money. It's about exceptional circumstances which could render non-clearance a breach. Then you've got the word then, which gives you an idea of sequencing. The decision maker must consider whether such financial requirement is met through taking into account the source of income. So the stage in which the stages you go through are, first of all, consider whether there are exceptional circumstances. And it's only if there is that, your opponent says real risk, that you then look at money. It's after you've looked at exceptional circumstances, but you're saying you look at the money in the first part of it. You look at it to see whether there are exceptional circumstances.
I appreciate, my lord, that it sounds like a circular argument, but I'd respectfully submit it's not, because in determining whether there
Am I right in you are putting the money assessment into B as opposed to after the then?
I'm respectfully submitting that the claimed presence of the money, the third party support or whatever it might be, has to be relevant to an assessment of whether Article 8 could be breached, rather than would be breached, which would be the case in Article 3.2.
Yeah.
And we would submit that, that there's no need at that stage to delve into the detail of the proposal for financial support. But the question a tribunal should ask itself is a question based, as it says in 3.1, on the information provided by the applicant. And that information includes, in this case, a claim that there is a sufficient alternate form of support. And we say that
That would be an exceptional circumstance.
we would submit that it's something that contributes to the possibility that Article 8 be breached because it weakens the public interest in favour of a denial of entry.
This approach completely removes the whole distinction between the specified sources and the alternative sources, doesn't it? Because if there are in fact alternative sources which would suffice, or particularly if they are ample, then effectively you'll never be able to say that they shouldn't be taken into account. So what you're really reading this as completely removing the distinction.
But we would submit that the distinction will still arise in cases where Article 8 isn't engaged, and that there might be cases, for example, where a couple are seeking to come to the UK together. One of them is a British citizen or a settled person returning to the country. There'd be no interference with their family life at all because they're currently living in a third country. We would submit in those circumstances, it would be arguable that there's no engagement of Article 8. There'd of course be other circumstances, and I appreciate this is a slightly different issue, where when the third party support is considered, it's found to be inadequate. But we would submit that the ability to consider third party support, if Gen 3.1 is read consistently with Lebanon, which is the case law that it purported to incorporate into the immigration rules, we would submit 3.1 has to be viewed as being extremely permissive, and not to do so, we would submit, would risk breaches of Article 8, because there'd be cases where the only reason people are being denied entry to the UK or the right to continue living in the UK is because they don't meet through the specified sources a minimum income requirement. They are accepted to have met through other sources, and we would submit.
That necessarily helps you. If you stand back from this, if you can't, if you haven't got the money, you're the applicant and you ain't got the money. But if entry clearance is refused, there's a real risk of an Article 8 breach. And therefore, the only thing that's holding you back at the moment is the money. In which case, having gone through the fact that there is a real risk of breach, unless they look at the money, they can look at the money. That's, I think, what 311B does. It says, first of all, are there circumstances, which means there's a real risk of breach, and the thing which is holding you back from getting entry clearance is the money. In those circumstances, then we can look at the money, because that may be the gap in your jigsaw which needs to be plugged. But the predicate for that is you've got to show that there's a real risk of an Article 8 breach, which is that which then triggers the right to look at the money to plug the gap. And that's why I think the sequencing is quite relevant. It's first of all show that there's a real problem. Your difficulty is you can't show the money, but because there's a real problem, an Article 8 problem, the entry clearance officer can look at the money to see whether or not that gets you over the hurdle you're facing. That's seems to me at least one cogent analysis of the reason why it's structured in this way, that the money doesn't come in at that stage. It comes in once you've established the exceptional circumstances, or the circumstances giving rise to a real risk of breach, to put it the appellant's way.
We'd respectfully accept that analysis, but
Why does that then help
within,
you?
but within what your lordship's just said is recognition that the only reason that somebody doesn't meet the requirements of the immigration rules is because of the money, and we would submit it's therefore necessary to consider that Article 8 is more likely to be breached if that person can come up with the money through an alternate source, and so the threshold for the engagement of 3.1 is much lower than it would be, for example, in 3.2, because the only problem, the only barrier under the immigration rules is the money, and that's a barrier that can be overcome. And we say a decision making looking at whether there's likely to be a breach of Article 8 is bound to consider whether such a breach would occur in circumstances where the only reason the individual hasn't succeeded under the immigration rules is one that can be dealt with. And we say that's more likely than in a case where somebody is impecunious and they've got no prospect of meeting the financial requirement.
It says you fall down on paragraph 41, because on the Upper Tribunal's analysis, there is no risk of breach of Article 8 unless you get into something entirely hypothetical and speculative, which you accept is problematic. In which case, money doesn't really help you either way.
That's why I'm framing the argument in this way, because the findings in paragraph 41 are that, and I'm reading from 3 lines down, that perhaps reading from the beginning, the consequences of the appellant being refused entry is that his family life with Mrs. Khera cannot be enjoyed in the UK, and in order for their family life to continue, Mrs. Khera, who is a British citizen, would need to leave the UK and return to India. This is a significant interference with Mrs. Khera's private and family life. Then it goes on to say it's not of itself an interference with Mrs. Khera's life that would result in unjustifiably harsh consequences for her. And that's because there are no insurmountable obstacles to relocating. Well, that would be the appropriate test under Gen 3.2. But when you're looking at Gen 3.1, we would submit that the use of the word could and the fact that it's focused on individuals who solely fail under the rules for financial reasons means that the tribunal ought to have concluded, as it in fact did in 42, that although of itself the interference with the family life wouldn't constitute unjustifiably harsh consequences that would breach Article 8, when the financial requirement is factored in and the ability to meet it through alternate sources is factored in, the public interest is sufficiently diminished that there is a risk of unjustifiably harsh consequences and a breach of Article 8. We would submit that.
So do you say that 41 is wrong?
We say that 41 is a decision that is reached without consideration of the ability to meet the financial requirement, which we would say would reduce the public interest. We would submit that the tribunal ought at that stage to have considered the hypothetical possibility that the financial requirement would be met through alternate sources of income, and had it done so, it would have concluded that there was potentially a breach of Article 8, there was a real risk that there'd be unjustifiably harsh consequences, and then would have been permitted,
Why?
as it did,
Why?
to look at Gen 3.1.
On the logic of 41, I'm not certain it follows, because I think the tribunal here is assuming that Mrs. Khera and the son would be able to live in the United Kingdom with the husband financially, but nonetheless sending them back to India or requiring them to go back to India to live a private and family life is not a breach of Article 8. So they have factored in the money here, haven't they? It's almost notwithstanding there is the money, there's still no unjustifiably harsh consequences because she can have a private life in India. I'm not certain why the money affects that analysis at all.
We would submit that the analysis in 41 is not looking at the money, it's looking at whether they would succeed were it not for the money issue and were it not for Gender 3.1. And then in 42, there's the consideration of the possibilities, all of which are possibilities that might arise in the future if there's a change in circumstances, and I accept that's not particularly helpful. But then the final sentence of 42, these are only possibilities, but mere possibilities enough to satisfy the conditions of Gen 3.11b. And but we would submit, it's clear from that that 41 is looking at the situation without regard to the finances, 42 is looking at it with regard to the finances, and finding that if regard is had to the finances, that Gen 3.1 is satisfied. And then if we look at 44, it says, as the appellant has a family life with Mrs. Khera, that engages Article 8.1 and the requirements of Gen 3.1 are met, it follows that it would be disproportionate to refuse him entry clearance. So we would submit that it's when the money is brought into the equation that the tribunal decide that what would otherwise not be a breach of Article 8 is a breach of Article 8. And we would submit that that's wholly consistent with MM Lebanon. And I did want to take you to that. And I wonder if now's a good time to do so. I know we've looked a little bit.
Very happy. Can I just ask you one question? Do you accept there's a distinction between the engagement of a right and the breach of the right? So you may be in a position where you have a right which is engaged, which is the use of the word in para 44, but that doesn't prejudge the question as to when it's violated.
I accept that. The right's engaged, and on the finding of the tribunal in 41, there's a significant interference with it. And it would be our submission that the combination of those two factors would, on any reasonable view, be enough to pass through the gateway for a consideration of Gen 3.1 and the alternate sources of funding that permits. What we say, that doesn't have to be a finding that Article 8 is breached in order to consider alternate sources of funding. There has to be a finding that it's engaged, it's interfered with, and there's a possibility of it being breached. I think where I'm struggling to convince your lordships at the moment is that the assessment of whether there's such a possibility is one that needs to take into account the claim that there's alternate sources of funding. And I would like to be permitted to develop that argument a little further. And sorry. So in the authorities bundle, we were looking at 270, which is where we find paragraph 99,
Yes.
100 of MM Lebanon. The first two sentences we say in paragraph 99 are important. Operation of the same restrictive approach outside the rules is a different matter. In our view, it's much more difficult to justify under the Human Rights Act, not because less intrusive methods might be devised, as Blake J attempted to do, but because it's inconsistent with the character of evaluation which Article 8 requires. And we would submit that the character of evaluation that's being referred to there is an assessment, a nuanced assessment of both sides of the proportionality balance, the side that favours the Secretary of State and the side that favours an individual. And we would submit, based on that, it can properly be argued that the presence or claimed presence of an alternate source of funding is relevant to the Article 8 balancing exercise, and to use the language of 3.1, to determining whether there are unjustifiably harsh consequences. Paragraph 100 starting 5 lines up from the bottom of that paragraph, speaking about decision makers. They are entitled to take account of the Secretary of State's policy objectives, but in judging whether they are met, they're not precluded from taking account of other reliable sources of earning or finance. It's open to the Secretary of State to indicate criteria by which reliability of such sources may be judged, but not to exclude them altogether. We would submit that a strict interpretation of Gen 3.1 would have the potential to exclude the consideration of other reliable sources of earnings altogether. And that wouldn't be consistent, we would submit, with NN Lebanon.
It would be, because you've got 3.2 and your consideration outside the rules. I mean, MM Lebanon, at the time of MN Lebanon, there wasn't this provision. So they were considering what they're expressly talking about the fact that an entry officer can consider these matters notwithstanding the rules and the guidance.
What they're saying is that they should be able to. The guidance at the time prohibited them from doing so,
They should be.
and that guidance wouldn't have been compliant with Article 8. And then we get the introduction through the memorandum to the Statement of Changes of 3.1 and 3.2, and 3.1 is the one that's focused on ensuring the possibility for a breach of Article 8 that was identified in MM Lebanon, we would submit.
But 3.1 is not concerned with an Article 8 decision. It's concerned with the procedural question about whether or not the entry officer should consider whether alternative circumstances constitute compliance with the rules. That leaves completely intact everything else in MM about the consideration of the Article 8 position more generally, doesn't it?
Well, we would submit no. We would respectfully submit that 3.1b plainly invites decision makers to consider Article 8. But it's necessary to consider whether there are exceptional circumstances which could render refusal of entry, clearance or leave to remain a breach of Article 8. That's a gateway to whether you can consider the alternate sources. You can't consider in our submission whether an individual passes through that gateway without looking at all of the features of the case, and as it says, all of the information provided by the applicant. So whilst it's looking hypothetically at whether Article 8 could be breached, that's not, we would submit, an exercise that could be completed without regard to all of the factors that are relevant to Article 8, including those that I've just identified from MM Lebanon, which is the need to have regard to the possibility of there being alternate sources.
The diversity of your argument, it seems to me, is that it takes a concern that an applicant's Article 8 right should not be breached. And it says, well, if there is a possibility that it might be breached, taking into account these alternative sources of funding, we have to look at the alternative sources of funding and then not decide the case on Article 8, but decide that there's entry under the rules. And so rather than Article 8 being the fallback position to ensure that somebody isn't refused entry where it will breach their Article 8 rights, it actually uses a possibility to give rise to a right under the rules to enter. And that seems to me to turn everything completely on its head.
But I'd respectfully submit on the language of 3.1, that's what it does.
Well,
It's plainly...
Forgive me, I think what I'm suggesting to you is that can't possibly be what is meant. That one takes Lebanon and the suggestion that that the Secretary of State could revise the rules to indicate circumstances in which alternative sources might be taken into account, and turn that into a situation where the mere possibility of a breach of Article 8 means that there is a right to enter under the rules.
If there's found to be an alternate source of funding that meets the stringent requirements that are set out in Appendix FMSE as to its reliability, its credibility, its genuineness. But we would submit that's what the Secretary of State's submission is to you, although the word real risk is used instead of mere possibility. Well, and if Mr. Biggs addressed you, that's we would submit the approach he's urging you to take.
But forgive me, whilst your arguments, I see what you're saying. At the end of the day, the only debate really, isn't it, is whether or not the word could means real risk or whether it means mere possibility. That's what it comes down to at the end of the day.
At its simplest, that's a distinction that perhaps needs to be explored, and I accept that. But I would submit that the likelihood of there being such a breach is increased if there is a possibility of third-party support or alternate sources of funding that weakens the public interest in denying entry or refusing permission to stay. And I would submit there's nothing perverse about that. It must be the case. And so the question a decision maker should ask themselves is, having regard to the possibility of the financial requirement being overcome in another way, there is a potential breach of Article 8, then we need to look and see whether that financial requirement is overcome in another way.
I can understand that argument, but I'm not sure it leads to the conclusion that mere possibility is the right threshold rather than real risk.
No, and I'm not focusing on a submission that mere possibility at some point in the future is the right threshold. I'd accept that the language of 3.1 focuses on the present, it focuses on the information that's currently before a decision maker. But we would submit that where the obvious effect of a decision is to deny entry to an excluded spouse who's seeking to join a settled spouse, there is a real possibility, and we would submit, or a significant risk, or whatever we want to call it, of it being unjustifiably harsh consequences. And we would submit that that increases.
You've got to take on board that that's not what the tribunal found in paragraph 41. I mean, you're sensible to sort of focus upon the real and now. And I see the point that the availability of money may be relevant, because it may take the sting out of the Secretary of State or the Entry Clearance Officer's concerns. But here, looking at the judgment, it does seem that the tribunal was alert to that point, because they come to the conclusion there is the money, but they quite clearly then say that we have to move on to consider whether there are exceptional circumstances in 40. So the alternative source of money is adequate, but the question is, are we entitled to look at it? And that means we've got to see whether exceptional circumstances will lead, if we don't look at it, will there be an exceptional circumstance leading to a breach of Article 8? Answer 41, no, unless we then come to this troublesome 42, which seems to make the threshold for finding a breach so low as to be almost meaningless.
Well, I accept it's troublesome, but I would submit that
Just so it boils down to, you're effectively saying that in 41, the tribunal found there was a significant interference with Mrs. Khera's private and family life, and that in and of itself, given that there was no financial problem, which they've already found, was sufficient to justify the anti-clearance officer granting clearance.
we would submit that the combination of those two factors was sufficient for a tribunal to conclude that there could be unjustifiably harsh consequences such that Article 8 is breached, and then to take into account the alternate sources of funding.
The alternative, they're neutral in this respect because they're not a problem. Tribunal has so found.
Forgive me, I didn't
They're
understand.
neutral in this respect because the tribunal has found they're not a problem.
We would submit that they're not neutral. The ability to meet the financial requirements weakens the Secretary of State's justification for the interference with the Article 8 rights, which is a
Logically, in
justification
some
of-
respect, that must be right.
Yes.
But I mean, you're effectively, you are necessarily having to take issue with paragraph 41 in the way in which they come to the conclusion that once they've found there's a significant interference with Mrs. Khera's private and family life, coupled with the fact that ain't a financial problem, that should have been sufficient to grant clearance.
And we would submit that would be sufficient, and that's the only conclusion the tribunal could have reached. I accept it's not the basis upon which they reached it because of what it says in 42, but we say 42 is incidental.
Can I be very formalistic? There's no respondent's notice raising this point, is there?
We're not saying it's a different provision that the tribunal should have applied. We're saying that they provide.
But you are in effect, I mean, we have to grapple with quite a fundamental point of construction and law here. So, you know, from my part, we may not want to be overly formalistic about it, but you are taking on paragraph 41. I don't want to criticise you for doing that, but I think you have to.
I'm not saying 41's wrong. Can I tell you why? Because 41 we would respectfully submit is concerned with the word would rather than the word could. And we can see that in particular from the second line up from the bottom of the page.
Okay.
And that needs to be viewed in the context where the tribunal, as has been said by my learned friend, was very much focused on the difference between would and could. And we say 41 is a set of findings on the would test, whereas 42 is findings on the could test. And what the tribunal is effectively saying is, if we were looking at whether there would be a breach of Article 8, we would find against the respondent, as he now is. But if we were considering whether there could be, we'd find in his favour. And it's our submission that although the examples that the tribunal gave in paragraph 42 were not particularly helpful, the conclusion in paragraph 42 that the could threshold was satisfied was the correct conclusion, and we would go as far to say the only permissible conclusion that was open to the tribunal in a case where spouses were either being separated or one spouse was being required to leave the country of her nationality and habitual residence to reside with another spouse. And we say that's the test that 3.1 envisaged. It wasn't applied perfectly by the tribunal, but they came to the right conclusion by a somewhat circuitous route.
It's helpful that, I mean, that analysis is helpful in understanding your point. I see that they use the word would twice in 41. In 42, they seem to equate that with likely, which is a lower degree of certainty than, you know, would, which is a finding of fact. It could be more akin to could, but I see the point you're making. I understand it. And you then say could is about a possibility or mere possibility, or something
A
like
realistic possibility.
Sorry?
A realistic
possibility. Okay.
But I would return to my submission that in assessing whether there is such a realistic possibility, you have to look at both sides of the Article 8 balance. not determining the ultimate issue, but determining whether Article 8 could be breached. The stronger the public interest in the denial of entry, the less likely it is that Article 8 will be breached. And if we like, there's a hierarchy of different public interest considerations, ranging from a serious criminal, perhaps at the high end, through individuals who have other grounds related to their conduct upon which to be refused for suitability. Then individuals who are unlawfully in the UK, the sort of precarious family life cases that were discussed in Agyarko and Jeunesse. And then we say that the bottom end of the hierarchy, the bottom rung, are individuals who've done nothing wrong, who are seeking to enter and who meet all of the rules, except a financial requirement, and they're advancing an argument that they can meet that through alternative sources of funding. And we say the public interest in those cases is so diminished that it doesn't take much in terms of a family life argument to overcome them in the proportionality balance. And remembering that for 3.1, the tribunal only has to consider whether the Secretary of State's justification for the interference could be overcome in the proportionality balance. We would submit that on any view of the findings in this case, including the findings about the genuineness, the credibility, commitment of the supporter, the only possible outcome is a decision that third-party funds should be looked at. And once they're looked at, we know the tribunal concludes that the appeal succeeds. We would submit it being an affront to common sense not to consider such a source of funding. The mechanism that's in place for the Secretary of State to do so is Gen 3.1. It applies to the tribunal as well. And we would submit that the absurdity that might arise in this case is the absurdity of not having regard to such solid source of funding when determining whether somebody's Article 8 rights are breached.
Okay, I understand that. Can I ask you one question about 3.12? So when the entry clearance officer does look at the alternative source of funding and concludes that the relevant requirement is met, then the applicant will be granted entry clearance or leave to remain as appropriate. But then you also have the words in the middle of 3.1.2, is met following consideration under paragraph 1 and provided that other relevant requirements of the rules are also met. What does that include? Does that include matters other than financial requirements?
We would submit yes.
Including general Article 8 requirements?
No, we would submit it. It refers to the other substantive requirements of the rules. And it's to prevent the paragraphs being read in a way that mandates a grant of entry clearance, despite the fact that other requirements of the rules may not be substantively
not
met.
Article 8 requirements, but other substantive requirements. So you could have a situation whereby all the requirements are now met. Strictly, there's no breach of Article 8, but nonetheless, entry clearance must be given because the financial requirements are met.
We would say yes, but to get to that stage, there has to have been the realistic possibility that Article 8 would be breached otherwise, because that's what we say is the gateway provision in 3.1. So we would submit a tribunal or a decision maker before they consider the alternate resources that are available, must first determine whether there's a realistic possibility of Article 8 being breached.
So I think that supports probably both of your arguments. It can't be a mere theoretical possibility. From a policy perspective, if could means realistic, then the decision maker, the entry clearance officer, is satisfied that for all practical purposes, we're dealing with a genuine Article 8 risk here, problem here. And therefore, only dealing with the financial requirements to plug the gap isn't going to leave the Secretary of State exposed on Article 8 grounds, granting clearance to people who really don't deserve it. Would that be fair?
We would submit that's fair, but it also works the other way around as well. It protects the Secretary of State from breaching people's Article 8 rights by not granting entry clearance in circumstances where Article 8's engaged and where they have an alternate source of funding.
That suggests could is doing quite a lot of work here to protect both the individual and the state in Article 8 terms.
I respectfully agree with that, and that's the way in which the Secretary of State decided to implement the recommendations in Lebanon, and I would submit that's the way in which the implementation has occurred. And what I'm submitting, I would respectfully submit, doesn't offend the language of 3.1. It's wholly consistent with it, and perhaps there's something else I should
That's
highlight.
right. Then 3.1.2 doesn't expose the state and the Secretary of State to a risk that there is a significant grant of clearance to people who are not breaching Article 8 by refusing them rights. There's no sort of policy daylight gap here because could is doing a lot of work.
We would submit no, because we would submit there's no policy objective that's served by denying entry to people who won't be a drain on public funds.
That's not necessarily an Article 8 issue. It may be part of it. But the Secretary of State's entitled to say for Article 8, you know, if there's no violation of Article 8, the fact that someone is not going to be a drain on funds isn't our only criteria. Maybe lots and lots of other policy things we want to impose, provided there's no breach of Article 8.
They would be covered by other aspects of the immigration rules and other considerations that the Secretary of State could bring into play, such as suitability refusals, refusals due to an inability to meet the English language requirement, etc. But the particular requirement we're looking at is financial requirement, and the objective of the financial requirement is an objective of protecting the economic interests of the country. And if those economic interests are not harmed by admitting somebody...
I get that entirely. And if there are other relevant requirements which say that not being a drain on state resources is one thing, but having a PhD in AI is another thing, then you would fail because although you're not a drain, you haven't got the PhD.
Yes. Could I refer your lordships, just in support of my contentions about the public interest, to the case of Rupia, which is the Supreme Court decision from 2018, which starts at 190 of the bundle, authorities bundle, I should say. In 197, sorry, page 197, there's a discussion which starts at paragraph 20 on page 196 of a different provision, but a provision that identifies the public interest, and it's 117B of the Nationality, Immigration and Asylum Act 2002, which was introduced in 2014. And about 4 lines down on page 197 of our authorities bundle, it says 117B, Article 8, public interest considerations applicable in all cases. And then what 117B does is set out a number of public interest considerations. They're actually numbered 1 to 6, although only the first 5 are reproduced in this part of Rupia. The relevant one is 117B3. It's in the public interest, and particularly in the interests of the economic well-being of the United Kingdom, that persons who seek to enter or remain in the United Kingdom are financially independent, because such persons are not a burden on taxpayers and are better able to integrate into society. And we would submit that that's the public interest that the Secretary of State is permitted to promote under Article 8 and is seeking to promote by imposing the minimum income requirement. In relation to that particular provision, the Lordship's opinion at paragraphs 53 to 54 at Authorities Bundle, page 205.
Sorry, 53 to...
53 to 55,
Thank you.
page 205.
Yes.
The Lordship set out the agreed position of the parties before the Supreme Court on that occasion. And it's to do with the very issue we're discussing today, which is third-party support. In paragraph 54, 4 lines down, in the MM and linked cases, this court considered the financial requirements imposed by the rules upon non-EEA family members wishing to join their relatives in the United Kingdom. The court held that adherence to the rules, which had sought to exclude reliance on promises of third-party support, even if credible, might precipitate a violation of Article 8. The rules were changed accordingly. And then the questions asked, rhetorically, I think, in paragraph 55, 3 lines down, why would it be in the public interest that they should not be financially dependent on other persons? Why would it in particular be in the interest of the economic well-being of the United Kingdom that they should not be dependent on them? And it was found that third-party support was sufficient for an individual to not be adversely impacted by the 117B 3 factor that somebody needs to be, what's in the public interest, that somebody's financially independent. And we would submit that that's a opinion of their lordships that makes direct reference to MM Lebanon. It clearly deals with the public interest factors that the Secretary of State is relying upon to justify the interference with the family life of the respondent's family. And we would submit it tends to suggest, perhaps even concludes, that such public interest concerns are not served by denying an individual the ability to rely on third-party support. And we would respectfully submit that that goes to the issue in which I'm attempting to persuade your lordships, which is that in deciding whether there could be unjustifiably harsh consequences, it's necessary to look at the strength of the public interest and the way in which it could be affected by the presence of third-party support, rather than simply looking at the consequences in isolation of the manner in which the Secretary of State is seeking to justify them. And so we say, for that reason, given the solidity of the findings on financial support from the Upper Tribunal, and given the engagement of Article 8, and given the consequences for the family of either separation or settled British citizens having to relocate, the only decision the tribunal could have reached under Gen 3.1 was one that did enable it to look at the third-party support and to allow the appeal, as we say, under the substantive rules, although because of the appeal framework that ultimately led to it being allowed on Article 8 grounds. And we would submit it's an affront to common sense, as I've said, I think, for the third time now, for the robust sources of support that are available in this case to be ignored. And the Secretary of State recognised that in Repair, was recognised in MM Lebanon, and we would submit the mechanism by which it is taken into account is 3.1, and any interpretation of 3.1 that's not consistent with that being the mechanism we would submit is likely to lead to breaches of Article 8. And when we're looking at the context and the purpose in order to interpret the provision, well, the context is it was implementing MM Lebanon, and the purpose we would submit is to ensure that the public interest is preserved and that there aren't breaches of Article 8. And we would submit the only way in which the provision can be interpreted in a way that's consistent with that and doesn't bring about the absurdity of not having regard to other means of support is for it to be interpreted in the way in which I urge. So unless I can be of any further assistance, really those are my submissions.
No, 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 Mr. Richardson. Thank you very much. Yes, Mr. Biggs.
Thank you very much, my lord. Just a few brief points. Firstly, as I understand my learned friend's analysis, it still relies on too low a threshold in respect of Gen 3.1. I think my learned friend's analysis has to depend on a combination of two things: mere engagement of Article 8 and the mere possibility of a breach of Article 8. That, in my submission, sets the threshold far too low. Secondly, as I understand my learned friend's analysis, it is incoherent in a number of respects. Firstly, it overlooks the procedural nature of Gen 3.1 and the stage of decision-making at which the rule applies. Bearing those things in mind, it would be incoherent and not possible to take into account, when assessing the real risk of a breach of Article 8, the claimed reliable alternative funding, because that is the very matter in issue. The decision maker applies Gen 3.1 to determine whether it is appropriate to even look at whether there is alternative funding available. So it cannot be assumed at that stage that there is such funding available. That would be to put the cart before the horse.
And that can't be a breach of Article 8 because you have 3.2.
That's a separate point I'm going to come to in the law, but I certainly accept that. Secondly, on incoherence, my learned friend's argument leads to a serious mismatch between Article 8 and the scheme under the rules, as the facts of this case show, because it cannot be denied, in my respectful submission, that the Upper Tribunal found as a fact at paragraph 41 that Article 8 would not be breached, even having regard to alternative sources of funding. And yet the appeal was allowed because of the Upper Tribunal's expansive interpretation of Gen 3.1. And finally, on incoherence, my Lord's point, as I understand my learned friend's analysis, it really adds nothing to Gen 3.2. And Gen 3.2 is available to ensure compliance with Article 8 so as to protect the individual and the state in the way that my learned friend suggests Gen 3.1 is trying to do. So my learned friend's analysis, if you like, does not put Gen 3.1 into its proper place in the scheme, bearing in mind Gen 3.2 and what Gen 3.2 is there to do. Finally, a point I made in opening that I just want to emphasise, there is no cross appeal from paragraph 41 of the Upper Tribunal's decision. There's no respondent's notice raising any point. And in my submission, paragraph 41 is fatal to my learned friend's case, because in circumstances where the Upper Tribunal has found that there is no breach of Article 8, even having regard to alternative sources of funding, then Gen 3.1 simply cannot have any purchase. So on analysis, my learned friend's argument probably boils down to a challenge to paragraph 41. My learned friend's point may be that the judge went wrong in assessing Gen 3.2, because at that stage he should have recognised that the public interest supporting the entry clearance officer's decision-making was diminished in the light of alternative sources of funding. But that point is not before my lords. It's not been raised by way of a cross appeal. It would need to have been. And in my submission, it's a bad point anyway, because the reasons given at paragraph 41 are sound. The respondent was part of a family unit that had lived in India quite comfortably for a period of time. And what the Upper Tribunal held in a nutshell was that Article 8 did not require a grant of entry clearance when the family was essentially chosen to relocate to the United Kingdom and could choose to live in India. That conclusion is entirely consistent with principles set out by the Strasbourg jurisprudence in Jeunesse and in the domestic cases, and is sound. And in the light of that conclusion, there simply was no real risk of a breach of Article 8. And so Gen 3.1 has no purchase. My lords, unless you have any questions, those are my submissions.
Can I just ask you about 3.1.2 and how that fits together? So if, as to some degree you both accept, could has some heavy lifting to do, and you get over the could in 3.1, the third party source of finance is looked at, it's found to be adequate,
Yes.
then you get into 3.1.2, provided that all the other relevant requirements are met, then entry clearance is considered. Do you accept that at that point there's no further role for Article 8 because it's been dealt with in this fairly heavy lifting could?
Yes, that must be how Gen 3.12 operates, and that's how the Upper Tribunal saw Gen 3.1. That's why it wasn't concerned about its finding under Gen 3.2 and Article 8 more broadly. So that's a fundamental difficulty in my respectful submission for my learning friends' analysis and the Upper Tribunal's analysis, because on both analyses, Gen 3.1 leads to results that significantly mismatch with what Article 8 requires.
Unless could does the heavy lifting.
Unless could works in the way that I've suggested, or in some similar way if my lords find a better way of trying to deal with the issue.
And would you accept that if the test is along the lines of, and
Thank you.
Mr. Richardson,
I think, yes, okay.
I don't want to put too much heavy lifting on my lord's shoulders, but
No,
what
just-
we're trying to do is to make the best sense of these provisions. and
understood. I mean, there's nothing necessarily straightforward about any of this, but I think Mr. Richardson accepted some sort of significant risk test or a realistic possibility.
Yeah. I mean, my learned friend at certain points in his submissions came pretty close to accepting my analysis, certainly in terms of the real risk formula. So I've explained why we've used the expression real risk to try to give some sensible and contextual meaning to the word could.
I understand that. Maybe my point is slightly different. If we adopted this sort of language, either real risk, realistic possibility, something along those lines, I think you accept that that would be sufficient protection for both the individual and the state under Article 8. If I use my very loose and inaccurate description, sufficient heavy lifting.
Yes. 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 There would, because of the different standard of proof, be some logical space.
There could be.
As my lord suggested earlier. But the word could has to be given some kind of meaning in contradistinction to the word would in Gen 3.2.
That's accounted for by the fact that we're at a procedural stage when you haven't looked at the money yet. So it's bound to be hypothetical, so therefore can't be would. But it's, if you like, the next best thing, and you say that it's definitely better than a possibility or mere possibility.
That's right, Lord. And it also means that in a case like this, where you can form the view that actually Article 8 wouldn't be breached, then there would be no real risk. So Gen 3.1 wouldn't apply.
Yep.
As I indicated in opening, the rule Gen 3.1 could have been expressed differently in hypothetical terms on the assumption that, so as to express the test on the basis of a hypothetical assumption that the third party source of funding is reliable. Then you look at whether there would be a breach. That's not the device that the draftsman used, but in my submission, whatever device the draftsman used, the substance should be the same.
Yeah.
That's my submission. I hope that's clear enough, Lord.
Thank you very much indeed.
Thank you. Anything else? No, thank you very much. Thank you for your respective submissions. We will reserve our judgments. They'll be provided to you in draft for the usual limited purposes, and we will deal with any outstanding matters on paper, although we would anticipate that once you've received our judgments, you will be able to agree the draft order. Thank you very much.
Court rise if you will.